but I don't see him. And
I apologize, Your Honor. My connection went out. I am here.
You're here. Okay, great. All right, let's go ahead and get started on that case. Let's go on the record on DC 22-14474, Duda versus Zimmerman et al. Counsel, make your appearances.
My name is Paul Leake. I'm the attorney for Vanna Duda, the plaintiff.
My name is Andrew Harding. I'm the attorney for the defendants in this case.
Did somebody else say something? I think somebody, you guys can mute if you're not in this hearing. All right, and then Ms. Huebner, you're here as well.
Yes, sir. I'm here on that case as well.
Okay. All right, let's go ahead and proceed. And Tony, we're going on the record on, did we already go on the record, Tony?
Yes, sir. We did.
Right, let's go ahead and proceed. Whose motion is this?
This is mine, Your Honor. We filed an original petition concerning real property and the appointment of a receiver. There is a house and lot located at 2001 Aloha Drive, Mesquite, Texas. And the legal description is set forth in the application. The property is owned by 3 people. My client owns 2/3. Tina Zimmerman owns 1/6, and Carol Nicholas owns 1/6 for a total of 100%. Therefore, we believe that it'd be in the best interest of this property to sell it, and by selling it, to appoint a receiver to sell the property, and then disperse the proceeds pursuant to the court's order.
Okay, response?
Your Honor, first and foremost, I'd like to clarify exactly what we're here on today. My clients were served 5 days ago, and at that time, there had already been a show cause order filed and signed in this case. Basically, I'm afraid that we're here on what's akin to a summary judgment hearing in which we bear the burden of proof for some reason on 5 days' notice as opposed to the traditional 21. And I believe that's a violation of my client's right to due process, Your Honor.
Is there a summary
exactly
judgment?
where we are in the case?
Is there a summary judgment that's been filed? I'm not aware of that.
Well, no, Your Honor, it's not summary judgment per se, but what the other side is requesting right now is essentially ultimate relief of a receivership being appointed, which is the relief that they've requested in their original petition. They're asking for their ultimate relief via show cause order. And we've had 5 days notice from receiving original petition and that show cause order, which were all done. Well, the show cause order was filed and signed prior to my clients ever being before the court in this case and cause. I'm not saying it is a summary judgment. I'm saying it has the effect and the weight of the summary judgment, and it's being forced upon my clients with 5 days notice.
I assume your client opposes the relief of having a receiver.
We do at this time, Your Honor. Quite honestly, there might be a solution to this case, but we've had 5 days notice. We received service of the original petition and the order to show cause on Tuesday of last week. My clients had to scramble to find an attorney and get filings on the record in the last 3 days. There may be a solution, there may be an amicable one, but when the process is rushed down the road like this before defendants are even served, it becomes hard to do anything but oppose the request.
Mr. Leake.
Your Honor, when you file an application for a partition, and in this case, appoint a receiver, the first thing you have to do after you file it is have the court issue a show cause order, just simply asking them to appear for the hearing. And then they were served with that show cause order at least 5 days before the hearing. And So now we're just simply asking the court to appoint a receiver to sell the property. This case has been ongoing between the parties for probably 6 months. And we were unsuccessful in working out the sale of the property without appointing a receiver.
You know, I guess my thought on this is that I'd rather give Mr. Harding a little bit of time to, you know, get his wits about him on the case. And so, Mr. Harding, how much time do you feel like you need to? I mean, this is
Your
kind of
Honor,
an expedited process, but that's the way partitions work generally. So,
that's fine. I wasn't sure if this was a petition or an original petition for partition or an action for declaratory judgment. I wasn't exactly sure because of the way the petition was styled, but that's fine. I'd need about 2 weeks with my current caseload, if that would be acceptable to the court.
yeah, that doesn't seem unreasonable. Have you met or are you familiar with Ms. Hubner, who's here today?
Let me check with my clients. Ms. Hubner? I am
Ms.
not, my
Hubner
clients
is
are not, Your Honor.
Just so you know, Ms. Hubner is the proposed receiver. She's who I generally
Okay.
use on these partition of residential cases. And so she's a longtime real estate agent who's done a great job for me in the past, a former JP as well. She's not an attorney and I've never had any complaints about her, but just, you know, I have no problem with resetting this. But
Right, Your Honor, and I may have, there may be something that can be agreed on or done with this case. I just need a little bit more time so that we aren't essentially railroaded by 5 days notice, Your Honor. So that's all that I'm really asking for today.
okay, well, just why don't I'm going to put you into a breakout room so you have a chance to kind of talk to Ms. Hubner and Mr. Leak about this. Do you guys want me to reset? I could reset this.
Could we at least talk first before you reset it?
Yeah, why don't I do that? I'll go ahead and put you into a breakout room. You guys talk, and then we can figure out a day for a reset. So I'm going to put Mr. Harding, Mr. Leak, and Ms. Hubner into a breakout room. You guys talk, and then we'll just come back. Do you guys know how to come back from a breakout room?
Yes, Your Honor.
Okay. So most people do at this point, but you'd be surprised. So I'm going to create a breakout room for you guys. Hopefully you guys can get something worked out. And I'm very flexible on reset if that's necessary. Is your client here with you, Mr. Harding?
They are, Your Honor.
Okay, good. Okay. Our next hearing is the summary judgment hearing. Palmer versus Hilton Worldwide, or is everyone here on that case?
Your Honor, good morning. Movement is here. Bill Arnold for the 2 Hilton entities.
Okay.
Your Honor, Greg Noche here for Gatehouse Capital.
Ms. Miles, are you here for this case or for a different case? You're muted, ma'am. You need to unmute, ma'am. Ms. Miles, you need to unmute.
Alec Pedigo would prefer that I didn't. I'm sure. Hi, Alec. Judge, I'm here for with Mr. Pedigo for the status conference on the Gannon Wallace Sherry matter.
Okay. I saw someone named Eric who was on here, didn't have a last name, but they're not here at this point. So we'll go ahead and start with this hearing. Tony, let's go on the record on DC 213379, Palmer versus Hilton Worldwide. Counsel, make your appearances.
Your Honor, Bill Arnold for the movements Hilton Worldwide, Inc. and Hilton Domestic Operating Company, Inc.
And Greg Noche for defendant Gatehouse Capital Corporation.
All right, let's proceed.
Your Honor, this is Bill Arnold, and before I proceed with our motion, I want to read into the record to the court an email that we received, that I received at 9:59 a.m. this morning from plaintiff's counsel. It says, it's short. It says, "Good morning. Due to health challenges and the fact that I recently underwent surgery/chemo and have been out of the office, could we reset this to the new year? I'm leaving the practice of law for health reasons and trying to get all my cases closed, but still have a few stragglers. Regards, Karen Thomas." So, Your Honor, we're prepared to go with this hearing. I know it's set for trial next year, but I just wanted the court to know about this email. I'm not trying to push something here. If Ms. Thomas has actually got some, it sounds like serious health issues. And so I just wanted the court to be aware of that.
I appreciate you telling me that, and I think that's exactly the right way to do this. It doesn't look like we do have a trial setting on this case. From what I could, you said there's a trial setting on this case?
Your Honor, yes, Your Honor.
Yes, Your Honor.
It is, I want to say it's, where do I have it?
You may be right. It's just not on
February the 7th of 2023, Your Honor,
February 7th.
is what I have.
Rhonda, can you, are you there? I don't see that this case is set for trial. Oh, here it is. Okay, there's agreed discovery plan. Let me see if this says it. Yeah, Rhonda, this case should, he's right. This case should be on the docket for February 7th.
Okay, I'll make sure it's on there.
And what I would suggest, unless there's a very strong objection to this, first off, it's unlikely that it will go on February 7th. We haven't been trying very many with the COVID backlog. We haven't been trying many 2021 cases, but we are catching up remarkably quickly. We're trying cases every week. It looks like we have some other hearings on this case on January 23rd. Mr. Arnold, would you feel comfortable if we just reset your hearing to January 23rd to give opposing counsel an opportunity to do what they need to do?
That's fine, Your Honor. And I will email plaintiff's counsel and copy other counsel on what is occurring this morning in this hearing, and let her know that the court has said that you do not think it's going to go to trial, but obviously she needs to please get new counsel in as soon as possible so we can proceed on this case. It's generally what I think I would put in the email, Your Honor.
And if she doesn't get it done by January 23rd, then we'll go ahead and go forward with this. But Rhonda, go ahead and reset this hearing to January 23rd. It looks like there's two hearings set that day. I'm not sure why, but
they're both summary. They're summary judgments on behalf of remaining defendants in the case.
Okay. So there's one at 10:15 and one at 2:45. I can add you on to either one. Which do you prefer?
The 10:15 is fine, Your Honor.
Okay. Rhonda, go ahead and reset this to 10:15 on January 23rd, 2023. Make sure that we get the trial setting onto the system. It's in the order. I'm not sure why it's not on the system. And go ahead and add that. And then anything else today, guys?
Your Honor, would the court like me to forward this email from plaintiff's counsel to the court? I can't remember if let me see if she included the court or not, just so it's in the record. She did not transmit it to the court. I'd be happy to do that or not.
It's totally up to you. I don't have a strong feeling. I trust you. And if you feel like you want in the record, I would probably attach it to a motion just so that it's hard to put an email directly into the
Okay, Your Honor.
It pretty much the clerks wanted in the form of either a motion, a notice, or a order. So you could put it in the form of a notice or a motion, or it doesn't matter to me. I don't.
Okay, Your Honor. At this stage, I might not, but I will do an email to all counsel with what I understand is the court's thoughts this morning.
And Rhonda, go ahead and just put a coordinator note in the system that plaintiff's counsel is ill and may be withdrawing.
Okay.
And that at least will document it in the system. All right. Anything else today, guys?
That's it, Your Honor. Thank you.
Thank you,
Nothing, Your Honor.
guys. And
Thank you.
thank you for letting me know about that, Mr. Arnold. I apologize for any inconvenience. So,
Yes, sir.
and we'll take care of this next month.
All right. Thank you.
Thank you. Happy holidays, guys.
You too.
Thank you. Thank you, Your Honor.
All right. Our next hearing is now our status conference, I guess.
Your Honor, Alex Pedigo for Dr. Stephen Sherry.
Yeah, so let's go on the record on DC 223389, Gannon v. Wallace. Counsel, make your appearances.
Alex Pedigo on behalf of Dr. Stephen D. Sherry.
Melissa Miles on behalf of Dr. John D. Wallace.
So, as I understand what this status conference is about, there was a motion to seal that the court heard last week, and one of the parties, and I don't remember which one, claimed they didn't get proper notice of the hearing. And so I set this for status conference just to try to clear that issue up. Who was claiming they did not get proper notice?
Your Honor, I was, Dr. Wallace was, Dr. Wallace didn't get a notice of hearing. Counsel didn't serve a notice of hearing. Their position is, as I understand it, that the posting of public notice, the order they got from the court, their motion to seal, that these things, I believe two of those documents, somewhere in the documents, and I'll give you an example. In the motion, I belatedly saw on, I believe it was the fourth paragraph of the section titled Background Facts, contained a reference to the date and time of the hearing. But what counsel did not serve was a notice of hearing. And horribly busy schedules rely on, I certainly rely on my paralegal who served with everything I'm served with on our e-file system to notify me of hearings that have been set and to get them on my schedule. So I understand that Mr. Pedigo's firm filed a brief on Friday regarding, in anticipation of this status conference, stating their position. And ultimately, they didn't file a notice of hearing. They didn't serve us with a notice of hearing. I don't think that's in dispute. But their reliance is on the rule, raise service of notice of hearing. That's Texas Rule of Civil Procedure 21, which says that a notice of hearing must be served on all parties no less than 3 days before the hearing, unless otherwise provided by these rules or shortened by the court. And their position is that because the rule regarding a motion to seal doesn't speak to notice of hearing given to the other parties in an action, that must mean that no notice is required. And that under Rule 21 provides an out for filing the notice, but Rule 21 doesn't.
I agree with you. If that's their position, I think they need to provide all parties notice of hearing on a motion to seal.
Your Honor, that's not our position.
Okay, so what is your position?
Our position is that we satisfied Rule 21 by satisfying Rule 76A. Not only does our motion have the date and time of the hearing, which was served on all counsel of record, including Ms. Miles, but our public notice that we filed a verified copy in the court and served via email and e-file on Ms. Miles and every other party in this litigation has the date, time, and place of the hearing, and in our public notice even has the Zoom link. That satisfies, and it was served 14 days, not just 3, 14 days before.
So you're not taking the position that because you posted, you put the other side on notice?
No, I'm taking the position that the Rule 76 notice is notice of the hearing. The only difference is it says public notice, and that was filed in the court and served on all parties. It has all the requirements met of 21B, A, and 76A. That's the notice that's required.
Ms. Miles, I get it. Ms. Miles, that does seem like proper notice. If he sent you a copy of the notice, I thought it was a situation where they posted and they thought that was good enough notice for you. And I would agree with you if that was the case. But if he sent you a copy of the notice and you guys just didn't attend, I think that's kind of on you.
Well, Judge, what they filed was a notice. It was a public notice of the motion. It was a public notice of the motion. Nothing they filed said notice of hearing. Nothing. And Mr. Pettigrew knows that's correct.
Mr.
Nothing
Pettigrew,
they
why don't
filed
you
said
share
notice
screen?
of hearing.
Can you share screen what you sent her?
Yes, Your Honor. It's also in your notebook and in our brief attaches exhibits. So let me pull up our brief. If you have your notebook in front of you, Judge, it's tab 6.
I can go grab it, but if you can pull it, it's in the other
I'm
room.
almost there. Got it.
It's gonna, yeah, if it's a problem, I can just go grab my notebook. But
Can you see this, Judge?
yeah, go ahead.
So this is what was filed,
Okay, can you?
right? This is just a verification. Hey, we filed the motion and we are attaching the public notice that we posted and filings pursuant to the rule. This is the public notice that was served on Ms. Miles and all counsel of record in this case as required by Rule 76A, which also satisfies Rule 21B. And here's the notice of hearing.
Yeah.
And if you could see at the top, Judge, like I said, what they filed was it's a notice of the motion. Had anything come across in the filings that there was a notice of hearing, it would have grabbed everyone's attention, like all notices of hearing grab our attention and our
Ms. Miles,
capital.
I respectfully disagree. I think this is sufficient notice. So I'm not going to vacate my previous. It gives you the time, the day. It's going to be on Zoom. So, all right, guys. Thank you so much. You guys have a great rest of your day. And if you want to file a motion to reconsider on this or whatever, I just wanted to make sure if this was a situation. I assume this was a situation where they were saying that they just did a public notice and posted it and thought that was good enough service, and that would not be good enough, but this is fine. So guys, have a great rest of your day.
Thank you, Your Honor.
Thank you. All right, Mr. Harding, Mr. Leake. Did we lose?
Yes, Your Honor.
I think we lost Ms. Huebner. I don't know.
Potentially, Your Honor. I think we're okay to proceed without her, at least for what we need to do here.
All right. What did you guys work out? Let's go back on the record. Just 1 second.
Sure.
Tony, let's go back on the record on DC 22-14474, Duda versus Zimmerman. Counsel, make your appearances.
Paul Leake, attorney for Vanna Duda.
Andrew Harding, attorney for the defendants in this case.
All right. The parties have had a chance to conference with each other and with the proposed receiver, and they're reporting back to the court. They were in a Zoom breakout room. You may proceed.
Your Honor, at this time, I think we'd like to go ahead and obtain that 2-week continuance if we could. I think there may be something that we can do just between the parties to potentially resolve this situation, but a couple days would be very, very helpful in obtaining that relief.
Okay, so these are your options for hearing dates, just so you know. We have on I know it's not 2 weeks, but January 19th in the morning. What is this? Okay, January 19th in the morning. Or you could do and that would be via Zoom or on, sorry, December 19th in the morning via Zoom, January 6th in person at the George Allen Courthouse, or January 9th via Zoom anytime during the day. What is your preference?
The 19th is fine with me, Your Honor. This is Paul Leak for Vanna Duda.
Is that December 19th, 7 days from now, Your Honor?
It's 7 days. I mean, if you want more time, I'm just giving you the dates we've got.
I'd prefer the January 9th setting via Zoom if at all possible, Your Honor. I'm hoping we don't need it at all.
Mr. Leak.
That's fine, Your Honor.
Okay, let's do January 9th. What time do you want?
In the morning, 10 o'clock.
Mr. Harding, does that work?
That's fine with me, Your Honor.
Rhonda, are you there? Rhonda, are you there? And Ms. Huber, I don't know if you heard us talking. We're going to reset this to January 9th at 10 o'clock. Rhonda, are you there?